IAS Barber 60-Day Rapid Revision, Rare, Series UPSC IAS Prelims 2022. Daily Handouts. Polity. 1. Evolution of Indian Legislature. Regulating Act of 1773. The first step was taken by the British Parliament to control and regulate the affairs of the East India Company in India. It designated the Governor of Bengal, Fort William, as the Governor-General of Bengal. Warren Hastings became the first Governor-General of Bengal. Executive Council of the Governor-General was established, for members. There was no separate Legislative Council. It subordinated the governors of Bombay and Madras to the Governor-General of Bengal. The Supreme Court was established at Fort William, Calcutta, as the apex court in 1774. Court of Directors, the governing body of the company, should report its revenue. Pitt's India Act of 1784. Distinguished between commercial and political functions of the company. Court of Directors for commercial functions and Board of Control for political affairs. Reduced the strength of the Governor-General's Council to 3 members. Placed the Indian affairs under the direct control of the British government. The company's territories in India were called the British Possession in India. Charter Act of 1813. The company's monopoly over Indian trade terminated. Trade with India was open to all British subjects. The power of the provincial governments and courts in India was also strengthened by the Act. Charter Act of 1833. Governor-General, of Bengal, became the Governor-General of India. First Governor-General of India was Lord William Bentinck. This was the final step towards centralisation in British India. It was the beginning of a central legislature for India, as the Act also took away legislative powers of Bombay and Madras provinces. The Act ended the activities of the East India Company as a commercial body, and from now on it became a purely administrative body. IAS Barber's 60 Days Rapid Revision, Rare, Series Notes, Day 1, Polity. Charter Act of 1853. 6 additional members were added to the Governor-General's Council. In other words, it established a separate Governor-General's Legislative Council which came to be known as the Indian, Central, Legislative Council. 4 out of 6 members were appointed by the provisional governments of Madras, Bombay, Bengal, and Agra. It introduced a system of open competition as the basis for the recruitment of civil servants of the company. Indian civil service opened for all. Government of India Act of 1858. The rule of company was replaced by the rule of the Crown in India. The powers of the British Crown were to be exercised by the Secretary of State for India. He was assisted by the Council of India, having 15 members. He was vested with complete authority and control over the Indian administration through the Viceroy as his agent. The Governor-General was made the Viceroy of India. Lord Canning was the first Viceroy of India. Abolished Board of Control and Court of Directors. Indian Councils Act of 1861. It introduced for the first time Indian representation in the institutions like Viceroy's Executive Legislative Council, non-official, and 3 Indians entered the Legislative Council. Legislative councils were established in centre and provinces. It provided that the Viceroy's Executive Council should have some Indians as the non-official members while transacting the legislative businesses. It accorded statutory recognition to the portfolio system. Initiated the process of decentralisation by restoring the legislative powers to the Bombay and the Madras provinces. India Council Act of 1892. Introduced indirect elections, nomination. Enlarged the size of the legislative councils. Enlarged the functions of the legislative councils and gave them the power of discussing the budget and addressing questions to the executive. 2. Evolution of separate electorates and Pune Pact. The Pune Pact was an agreement between M.K. Gandhi and B.R. Ambedkar signed in the Yerwada Central Jail, Pune on September 24, 1932. It was on behalf of the depressed class for the reservation of the electoral seats in the legislature of the British government. It was signed by Ambedkar on behalf of the depressed classes and by Madan Mohan Malviya on behalf of Hindus and Gandhi to end the fast that Gandhi was undertaking in jail. Gandhiji held hunger strike against the decision made by British Prime Minister Ramsay MacDonald. The decision was to give separate electorates to depressed classes for the election of members of provincial legislative assemblies in British India. 3. Evolution of Indian federalism. Indian constitution is said to be a federal structure only because it is said that it has clear demarcation of boundaries between central and the state government similar to that of US India having legislative and executive authority divided between the centre and the state. Chief essentials for a constitution to be federal are: dispersion of powers between the centre and the states forming federation. Rigidity, neither the centre nor the state has power to amend the provision of constitution relating separation of powers. Supremacy of the constitution, neither of centre nor states have power to nullify the constitution. An independent body and unprejudiced authority, e.g., judiciary. 4. Indian Councils Act of 1909. This act is also known as the Morley-Minto Reforms. Direct elections to legislative councils, first attempt at introducing a representative and popular democracy. It changed the name of the Central Legislative Council to the Imperial Legislative Council. The member of the Central Legislative Council was increased to 60 from 16. Introduced a system of communal representation for Muslims by accepting the concept of separate electorate. Indians for the first time in Viceroy's Executive Council. Satyendra Prasanna Sinha, as the law member. 5. Government of India Act of 1919. This act is also known as the Montagu-Chelmsford Reforms. The central subjects were demarcated and separated from those of the provincial subjects. The scheme of dual governance, diarchy, was introduced in the provincial subjects. Under the diarchy system, the provincial subjects were divided into two parts, transferred and reserved. On reserved subjects, governor was not responsible to the Legislative Council. The Act introduced, for the first time, bicameralism at the centre. Legislative Assembly with 140 members and Legislative Council with 60 members. The Act also required that the 3 of the 6 members of the Viceroy's Executive Council, other than Commander-in-Chief, were to be Indians. Provided for the establishment of the Public Service Commission. 6. Government of India Act of 1935. The Act provided for the establishment of an All-India Federation consisting of the provinces and the princely states as units. But the envisaged federation never came into being. 3 lists. The Act divided the powers between the centre and the units into items of 3 lists, namely the federal list, the provincial list, and the concurrent list. The federal list for the centre consisted of 59 items, the provincial list for the provinces consisted of 54 items, and the concurrent list for both consisted of 36 items. The residuary powers were vested with the Governor-General. The Act abolished the diarchy in the provinces and introduced provincial autonomy. It provided for the adoption of diarchy at the centre, introduced bicameralism in 6 out of 11 provinces. These 6 provinces were Assam, Bengal, Bombay, Bihar, Madras, and the United Province. Provided for the establishment of Federal Court. Abolished the Secretary of State's Council of India. Indian Independence Act of 1947. It declared India as an independent and sovereign state. Established responsible governments at both the centre and the provinces. Designated the Viceroy India and the provincial governors as the constitutional, normal heads. It assigned dual functions, constituent and legislative, to the Constituent Assembly and declared this Dominion Legislature as a sovereign body. 7. Union versus Territory of India. With reference to the government in India, the 2 terms, namely Union of India and Territory of India, have specific meanings. While the former stands for the states that share federal powers with the union governments, the latter include not only the states but all other units like the union territories. I.e., the Territory of India covers the entire territory over which Indian sovereignty is exercised, while Union of India covers only the federal system. Unlike the states of India, which have their own governments, union territories, UTs, are the federal territories, administered by the Union Government of India. In UTs, the central government appoints the Lieutenant Governor, who is the administrator and the representative of the President of India. 8. Constitutionalism, limited government. Constitutionalism means limited government or limitation on government. It is antithesis of arbitrary powers. The antithesis of constitutionalism is despotism. Constitutionalism recognizes the need for government with powers but at the same time insists that limitation be placed on those powers. A government which goes beyond its limits loses its authority and legitimacy. Therefore, to preserve the basic freedoms of the individual, and to maintain his dignity and personality, the Constitution should be permeated with constitutionalism. It should have some inbuilt restrictions on the powers conferred by it on governmental organs. 9. Parliamentary system, responsible government. Parliamentary system, democratic form of government in which the party, or a coalition of parties, with the greatest representation in the parliament, legislature, forms the government, its leader becoming prime minister or chancellor. Executive functions are exercised by members of the parliament appointed by the prime minister to the cabinet. The parties in the minority serve in opposition to the majority and have the duty to challenge it regularly. Prime ministers may be removed from power whenever they lose the confidence of majority of the ruling party or of the parliament. 10. Federalism, vs. unitary system. Federal government, unitary government. The system has multiple hierarchy levels, with both the central authority and the states, or provinces, both being sovereign. There is no hierarchy of sovereign powers. The central or national rules override the state rules. States have no authority to pass their own laws, and the central or national government can order the states to do anything. There is a balance between the levels of government. The federal government arrogates a huge share of power. Examples include Japan and Saudi Arabia. Power and responsibilities are shared between national and local levels. Power is placed in one central governing system. 11. Separation of powers and checks and balances. Legislature, Parliament, Lok Sabha and Rajya Sabha, state legislative bodies. Executive at the central level, President at the state level, Governor, Judiciary, Supreme Court, High Court, and all other subordinate courts. The Parliament is competent enough to make any law subject to the conditions of Constitution, and there are no restrictions on its lawmaking powers. Article 245, Extent of laws made by Parliament and state legislature. The President power and functions are given in the Constitution itself, Article 62 to Article 72. The judiciary is self-dependent in its field, and there is no obstruction with its judicial functions either by legislature or the executive. Article 50, Separation of judiciary from executive. Instruments of checks and balances. Legislature control. Impeachment and the removal of the judges. Power to amend laws declared ultra vires by the court and revalidating it. Through a no-confidence vote it can dissolve the government. Power to assess works of the executive through the question hour and 0 hour. Impeachment of the president. Executive control. Making appointments to the office of Chief Justice and other judges. Powers under delegated legislation. Authority to make rules for regulating their respective procedure and conduct of business subject to the provisions of this Constitution. Judicial control. Judicial review, i.e., the power to review executive action to determine if it violates the Constitution. Unamendability of the Constitution under the basic structure doctrine pronounced by the Supreme Court in Kesavananda Bharati case 1973. 12. Reorganization of states, committees and chronology. In 1948, the committee was appointed by the government to look into the need for the reorganization of states on a linguistic basis. However, the Commission preferred reorganization of states on the basis of administrative convenience, including historical and geographical considerations, instead of on linguistic lines. In December 1948, the JVP committee comprising Jawaharlal Nehru, Vallabhbhai Patel and Pattabhi Sitaramaiah was formed to study the issue. The committee rejected the idea of reorganization of states on a linguistic basis but said that the issue could be looked at afresh in the light of public demand. In 1953, the first linguistic state of Andhra for Telugu-speaking people was born. On December 22, 1953, Jawaharlal Nehru appointed a commission under Fazl Ali to consider these new demands. The commission suggested that the whole country be divided into 16 states and 3 centrally administered areas, and language be considered as one of the criteria for division. However, the committee rejected the idea of one language, one state formula. The government, while not agreeing with the recommendations entirely, divided the country into 14 states and 6 union territories under the States Reorganization Act that was passed in November 1956. 13. Domicile versus citizenship, NPR versus NRC. NPR. According to the citizenship rules, notified on December 10, 2003, NPR is the register containing details of persons usually residing in a village or rural area or town or ward or demarcated area within a ward in a town or urban area. NPR is not a citizenship enumeration drive. It would also include a foreigner staying in an area for more than 6 months. NRC. NRC is a register containing details of Indian citizens living in India and outside India. NRC will contain details of only the citizens of India, excluding the foreigners staying in India. NRC is a verified digital register containing names and basic demographic information about all Indian citizens in a digital format. A person born in India or having Indian parentage or having resided in India for at least 11 years is eligible for Indian citizenship. 14. Justiciability of ideals of Constitution. Fundamental rights are justiciable, enforceable by courts. In case of a violation, a person can approach a court of law. Fundamental duties have been regarded as a code of moral precepts due to their non-justiciable character. Directive principles of state policy, DPSP, are non-binding in nature and they are not enforceable by the courts for their violation. The ideals of preamble tread the same path of directive principles. They are non-justiciable in nature but they form the ethical and legal base for any judgment given by the courts of law. 15. Getting and losing a citizenship, Mehul Choksi case. Citizenship. Constitutional provisions. Citizenship is listed in the Union list under the Constitution and thus is under the exclusive jurisdiction of Parliament. The Constitution does not define the term citizen, but details of various categories of persons who are entitled to citizenship are given in Part 2, Articles 5 to 11. Unlike other provisions of the Constitution, which came into being on the 26th of January, 1950, these articles were enforced on the 26th of November 1949 itself, when the Constitution was adopted. Acquisition of Indian citizenship. The Citizenship Act of 1955 prescribes 5 ways of acquiring citizenship, viz., birth, descent, registration, naturalization, and incorporation of territory. Citizenship Amendment Act, 2019. The Act amended the law to fast-track citizenship for religious minorities, specifically Hindus, Sikhs, Buddhists, Jains, Parsis, and Christians, from Afghanistan, Bangladesh and Pakistan who entered India prior to 2015. The requirement for them to stay in India for at least 11 years before applying for Indian citizenship has been reduced to 5 years, by naturalization. Ways to renounce citizenship in India. Voluntary renunciation. If an Indian citizen wishes, who is of full age and capacity, he can relinquish citizenship of India by his will. When a person relinquishes his citizenship, every minor child of that person also loses Indian citizenship. However, when such a child attains the age of 18, he may resume Indian citizenship. By termination. The Constitution of India provides single citizenship. It means an Indian person can only be a citizen of one country at a time. If a person takes the citizenship of another country, then his Indian citizenship ends automatically. However, this provision does not apply when India is busy in war. Deprivation by government. The government of India may terminate the citizenship of an Indian citizen if the citizen has disrespected the Constitution, has obtained citizenship by fraud, the citizen has unlawfully traded or communicated with the enemy during a war. Within 5 years of registration or naturalization, a citizen has been sentenced to 2 years of imprisonment in any country. The citizen has been living outside India for 7 years continuously. Points to be noted. Laws made before the Charter Act of 1833 were called regulations and those made after are called acts. Lord Warren Hastings created the office of District Collector in 1772, but judicial powers were separated from District Collector later by Cornwallis. From the powerful authorities of unchecked executives, the Indian administration developed into a responsible government answerable to the legislature and people. The development of the portfolio system and budget points to the separation of power. Lord Mayo's resolution on financial decentralization visualized the development of local self-government institutions in India, 1870. 1882, Lord Ripon's resolution was hailed as the Magna Carta of local self-government. He is regarded as the father of local self-government in India. 1924, railway budget was separated from the general budget based on the Ackworth Committee report, 1921. From 1773 to 1858, the British tried for the centralisation of power. It was from the 1861 Councils Act they shifted towards devolution of power with provinces. 1833 Charter Act was the most important act before the Act of 1909. Till 1947, the Government of India functioned under the provisions of the 1919 Act only. The provisions of the 1935 Act relating to federation and diarchy were never implemented. The Executive Council provided by the 1919 Act continued to advise the Viceroy till 1947. The modern Executive, Council of Ministers, owes its legacy to the Executive Council. The Legislative Council and Assembly developed into Rajya Sabha and Lok Sabha after independence.